Welcome back to Environmental Laws with Thompson Hine. I'm happy to be back with you for another episode. My name is Joel Eagle, and I'm a partner in Thompson Hine's Environmental Practice Group in Cleveland, Ohio. As a reminder, LAWS stands for Land, Air, Water, and Safety. And in each episode, environmental attorneys at Thompson Hine will be talking about a timely and relevant environmental law topic. In previous episodes, we've talked about issues including how to manage environmental risks during the global pandemic, strategies for plant closures, understanding environmental criminal law, a tribute to the late, great RBG and her environmental record, handling OSHA inspections, and hot topics in Canadian environmental laws with our friends up north at the Gowlings Law Firm. Today, I'm joined by my colleague, Ray Blattner. Ray is a partner in Thompson Hine's Environmental Practice Group in Dayton, Ohio, and he's also the office partner in charge of the Dayton office. Ray has decades of environmental law experience, and I'm looking forward to chatting with him about this fast-moving topic of PFAS chemicals. Ray, happy spring to you, and I'm happy to be here talking about one of my favorite topics, PFAS.
Well, greetings, Joel, and to all listeners. It's a pleasure being here with you, and look forward to sharing this information.
I hope I didn't violate any ageist comments by saying that you have decades of experience, but I guess that's just an accurate statement, right?
It hurt just a little bit.
Okay, well, you can take that out of me later. All right, so let's get right to it. There's so much to talk about with this topic, Ray. We want to cover as much as we can in a short period of time. And this may sound controversial, but I'm going to say it anyway. I think the most complex part of a PFAS discussion is just knowing what to talk about and when to stop, because there is just so many topics, and each topic has subtopics, and you could go on and on. But I'm going to start with a quote from President-elect Biden's 2020 Environmental Justice Plan, where he specifically addresses PFAS. And I think the quote, it's very short, but it sets the table quite well for what we should be expecting in the coming years. The quote is, "Instead of making empty promises with no follow-through, Biden will tackle PFAS pollution by designating PFAS as a hazardous substance, setting enforceable limits for PFAS in the Safe Drinking Water Act, prioritizing substitutes through procurement, and accelerating toxicity studies and research on PFAS." So there's a lot to unpack there, Ray, and I know we'll be getting to some of the specifics there, but clearly Biden is focusing on PFAS specifically, and we've seen already some fairly significant action, right?
Absolutely. At the federal level, U.S. EPA's regulatory initiatives began in earnest with its December 2019 unveiling of its PFAS action plan. The plan called for the evaluation of the need for drinking water standards for PFOA and PFAS chemicals, two of the most prevalent PFAS substances, designation of PFOA and PFAS as hazardous substances, thereby subjecting those materials to potential claims under the Federal Superfund Law, or CERCLA, for investigation and cleanup, issuance of groundwater cleanup recommendations for PFOA and PFAS, and the development of toxicity values for certain of the PFAS chemicals. Over the shorter term, the plan calls for development of new analytical methods for accurate measurement of the PFAS materials, annual reporting under the Emergency Planning Community Right to Know Act's Toxic Release Inventory Program, and, not surprisingly, enforcement. Over the shorter term, the plan hoped for the development of new analytical methods. Congress legislatively embraced the action plan, incorporating its elements in the National Defense Authorization Act for fiscal year 2020 in December of 2019. Besides adopting those items in the action plan, it also established groundwater cleanup guidance, setting a screening level of 40 parts per trillion, that's trillion with a T, and establishing preliminary groundwater remediation goals of 70 parts per trillion. As directed by Congress, in June of 2020, EPA added 172 PFAS materials to the Epra Toxic Release Inventory annual reporting requirement. That reporting requirement is applicable to companies that manufacture, process, or otherwise use 100 pounds per year of any of the 172 PFAS chemicals. That's an extremely low threshold. And the first report is due July 1 of this year, barely 3 months from now. So companies should be assessing today their operations and supply chains for the presence of any of those 172 PFAS chemicals. There is a de minimis exemption. It is 0.1% for PFOAs and 1% for PFAS. That is, those percentages in any of the materials that go into their manufacturing process.
So Ray, there's one thing that I think listeners, I like to say this whenever I explain PFAS, and that is there isn't one PFAS compound. There aren't 10 or 172 like that are subject to Epra. There are thousands, and I have not read 2 articles or papers that describe the number the same. It's either 4,000 or 5,000 or 6,000 or 6,000 plus, but all PFAS are not the same. That's why there have been regulations at the state level for PFOS, PFOS, PFOA, PFOA, PFNA, and several others, but not so many more PFAS compounds. So I try to pronounce it a little bit different: PFAS versus PFAS. But as with any chemical, EPA and any state agency does or should be regulating based on human health and environmental risks. And the toxicity studies for the large number of PFAS chemicals is really in its infancy. PFOS and PFOA are the only 2 that have fairly substantial toxicity evaluations, such that states are now, feeling comfortable passing their own regulations, and that's why U.S. EPA is focusing on these 2 in particular. But I always like to remind people, because there's this tendency to just say PFAS. Well, we're sampling for PFAS, and you have to be everyone has to be careful with how they describe that.
Oh, absolutely. Good point. And it'll be interesting to see which chemicals, which of the 5,000 U.S. EPA and the states target in the weeks and months ahead. Most of the focus has been on groundwater contamination, but recently U.S. EPA has issued its interim strategy for PFAS in federally issued wastewater permits. Those are the National Pollution Discharge Elimination System permits, typically issued by states, but there are several states where the feds do the permit issuance. But so there's a with respect to the wastewater discharge, there's a shift from drinking water to wastewater and impacts on surface waters primarily. The interim strategy calls for monitoring. They've identified 40 particular PFAS materials for the initial monitoring requirements. And while there are no effluent limits, no specific discharge restrictions, the strategy calls for implementation of best management practices to control the wastewater content, the PFAS content of the wastewater. What those BMPs will be remains to be seen, and likely states are going to adopt their own version of this strategy, and we'll see the best management practicing evolving over time. In December, just last December 18, EPA also issued guidance on the destruction and disposal of PFAS and materials containing PFAS. The agency has identified several preferred, if you will, destruction and disposal methods, most notably combustion, typically incineration, and thermal treatment. However, a number of concerns have arisen regarding the problems caused by incomplete destruction in terms of ambient air concentrations. In fact, Sierra Club has sued the Department of Defense to prevent incineration of its aqueous firefighting foams because of the concern about incomplete destruction and the resulting air impacts. Hazardous waste landfills are also identified as a preferred method of disposal, as are solid waste landfills, but only if those landfills are equipped with liners, leachate collection, and treatment systems. Important to note that EPA has a focus in the Biden administration on environmental justice in connection with permitting of pollution-creating activities, as well as a general approach regarding impacts of industry in communities. And these environmental justice considerations were specifically noted in the strategy. And so it's clear that vulnerable communities in the immediate vicinity of disposal or destruction areas are going to be, their voices will be heard in the permitting process. In mid-January, EPA issued an advance notice of proposed rulemaking to regulate PFOA and Pfas as hazardous waste and hazardous substances. Again, as I mentioned earlier, this would subject those materials to the CERCLA investigation and cleanup program. To date, nearly 250 of these Superfund sites around the country have confirmed PFAS detections in groundwater, and in fact, concentrations exceed the 70 part per trillion agency guidance at 47 of these sites. Finally, with respect to federal initiatives, in February, just a couple of weeks ago, EPA issued two more rulemaking initiatives. One, EPA announced its final determination to proceed with establishing drinking water standards for PFOA and Pfas. This determination required EPA to find that those materials may have adverse health effects, check, substantial likelihood that contamination occurs with a frequency and at levels of public health concerns, check, and regulation will reduce health risks. We hope that's the case, so that remains to be seen. Finally, EPA has proposed requiring community water systems serving over 3,300 citizens to monitor for 29 specific PFAS materials. That monitoring is to occur between 2023 and 2025. So that's what's been happening in recent months. There's much more to come at the federal level.
I feel like this is one of those, well, how else was the play, Mrs. Lincoln situations? I mean, there's just so much going on, and you just touched upon in a short period of time 5 or 10 different categories just at the federal level, and haven't even scratched the surface about the state level. We know that states are taking their own action. They've been taking their own action for years. There was a sense that the federal government wasn't moving fast enough. I think states were happy to see the February 19 federal action plan, but thought it was a little, too late, or just too late. So many states like New Jersey and Michigan and California, Minnesota, New Hampshire, so many states are doing their own thing. And one of my takeaways here is that there's a reason that the states are doing this. There's a crazy amount of investment and time to do all these things, and I don't think states would do them if they didn't, feel very strongly that there was a reason for it. And PFAS are so unique in the world, just in the world in general. They're globally used. They've been used for a very long time. They're unique because of the properties they exhibit. They are very highly stain resistant, heat resistant. They grease resistant. So you see them in so many different applications like carpet and other fabric stain resistant applications. You see them in waterproofing. You see them in flame retardants. Ray, you mentioned the AFFF, the aqueous film forming foam. That's the foam that's used to put out petroleum and other fires that can't be put out with water. And this AFFF has been used since the 1960s without being too dramatic or hyperbolic. It's been used everywhere. I mean, it's been used at airports. It's been used at Air Force bases. It's been used at facilities for firefighting purposes. It's been used for training exercises, which I think is one of the major issues. There are only so many fires that have needed to be put out with AFFF, but you have to be prepared for it. So you spray the AFFF in training exercises, and it of course gets into the groundwater. And previously it wasn't a concern, or it wasn't understood to be the concern that it is today. And you hear that Department of Defense facilities, for example, are the elephant in the room in the PFAS contamination world, just because of the amount of AFFF used at firefighting at Air Force bases. And Ray, I think close to home, you have an Air Force base with known PFAS issues, don't you?
We do. That's the Wright-Patterson Air Force Base. And, it's really a life and death issue with the firefighting foam. It is a very effective flame retardant. And the military, as well as aviation industry, is reluctant to move away from something that works. But we're certainly seeing the concerns being raised. And as of now, I believe the Department of Defense is not using the PFAS firefighting foams for training exercises anymore, but they're still going to use them in an actual fire. So there's a tension there, as there often is in these environmental issues.
Yeah, and at firefighting, local firefighting departments across the country, and I know in Ohio, Ohio has been trying to, recall isn't the right word, but request that firefighting departments turn in their AFFF with PFAS in it. But as you just said, it's life and death, and there really aren't suitable alternatives at this point. So it puts firefighters and those in need of firefighting applications in a very precarious spot.
Yeah, very much so. And you mentioned the states, Joel, and you're right. The states are taking the lead in many respects. No doubt the federal programs will trickle down to the states, but the states are not waiting for that. At least 6 states have established maximum contaminant level drinking water standards that are significantly more stringent than the federal recommended 70 parts per trillion. These are numbers between 8 and 20, parts per trillion, between 8 and 20 parts per trillion. Many other states have issued guidance at low levels without enacting actual drinking water standards. California is requiring purveyors of drinking water to notify the State Resources Board if they find detection levels above 5 for various PFAS materials. And states are now starting to look at air emissions. New Hampshire has issued a permit that requires the source to employ a thermal oxidizer to eliminate PFAS from the emissions. And I think you mentioned, Joel, one of our favorite states for environmental regulation, New Jersey. And I grew up in New Jersey. My father used to say, wherever the country is going, New Jersey will get there first. And I think that's certainly the case with respect to, in many regards, with respect to environmental. New Jersey has a very aggressive property transfer law that requires investigation and, in some cases, remediation of environmental conditions prior to a deal going forward. And they have now included in the required preliminary assessment an obligation to consider PFAS. So states are getting very aggressive with this. Ohio has last year conducted monitoring at 1,500 public water systems Many states are doing that sort of inquiry. Ohio was fortunate, only found detections in 6% of the public water systems, but virtually all of those were below the 70 part per trillion guidance that Ohio has adopted. Two systems were above those action levels. So far, so good in Ohio.
It's a relief to hear that, because when you consider the media coverage and environmental regulations at the state and federal level about PFAS, you would think that the word du jour is ubiquitous. And I would say whoever first used that word, Ray, ubiquitous, with PFAS, if they got a dime for every time somebody's used ubiquitous regarding PFAS, they would be a billionaire right now. But this idea that it's everywhere, it's been tested now in Ohio and in many other states, and you can't necessarily draw major conclusions, but at least in Ohio, it's nice to see that it hasn't been detected at extremely high levels. Of course, at places like Wright-Patterson, it was, and remediation is going to be needed there.
Yeah, Joel, whenever these programs come into place and public awareness is raised, inevitably litigation follows. That seems to be happening in the world of PFAS. Is that correct?
Sure. Yeah. I mean, there's litigation pretty much at every theory, every statute, plaintiffs law firm, states. It's been going on for years. This is not necessarily a novel in that PFAS litigation has just started, but it's been happening for many years now, and it's growing significantly. There have been recent settlements in many states, actions brought by attorneys general, like in Minnesota and Ohio. You've got settlements here that are in the nine digits, high nine digits, $650, $850 million, and that's going to cover damages, including to natural resources, and to cover ongoing remediation, or at least sampling. You have private actions. Ohio has a private action going on right now, trying to certify a class. Ray, get this, for everyone who has PFAS in their blood detected at a level that probably 99% or higher of the U.S. population would fit into that class. So if that doesn't boggle your mind of what sort of risks are involved, and the stakes for such a class action, I don't know what does. New Jersey is going hard, just like they are with the regulations. They have filed suit against companies for specific sites. One site in New Jersey has on-site contamination of one of the PFAS chemicals, PFNA, at 482,000 parts per trillion. And again, the MCL is 13. So you're talking many orders of magnitude above the MCL. With offsite contamination too, that's a lawsuit that started in November. In January of 2021, New Jersey filed suit against the federal government for 3 Air Force bases in New Jersey. So, no party is safe from the wrath of PFAS litigation.
That's good news for plaintiffs' lawyers.
I suppose, yeah.
PFAS concerns are making their way into business transactions as well now. It is the rare acquisition or sale of a manufacturing concern, or a site that historically has been used for industry, that does not involve a thorough environmental investigation. And in fact, as no doubt many of our listeners are aware, CERCLA and many state statutes provide a safe harbor for buyers of industrial properties, provided they conduct what's referred to as all appropriate inquiry prior to the acquisition. And the standard for an all appropriate inquiry is a phase 1 environmental site assessment that meets the criteria set out in ASTM's 1527 standard. That protection remains in effect even if the investigation turns up contamination, provided the buyer, after becoming the owner, does not exacerbate existing problems, does not create new environmental conditions, cooperates with the state, and takes reasonable measures to address ongoing releases that may have been discovered. However, the ASTM standard today says nothing about PFAS, and word to the wise, I think, for any purchaser of industrial property or historic industrial property would be to include PFAS concerns in the phase 1 environmental site assessment. And of course, it isn't just the site itself. One should be looking for red flags with respect to the neighboring properties. Are you near a military base? Is the targeted property next to or near an airport? What have been the past uses of the premises? Are there PFAS in the supply chains for that site? And you mentioned fabric coatings, food packaging, clothing, so many consumer and industrial uses that employ PFAS. Was there a fire at the facility? Might this firefighting foam have been used? So it's important to include PFAS these days, I believe, in pre-acquisition due diligence. And then, of course, negotiations between buyer and seller will ensue regarding including protections in the representations and warranties and indemnities. But this is certainly a trend now. Add it to the list of many other chemicals of concern that buyers and sellers have negotiated for years now.
Right. And this is just one of those areas where we don't have enough time in the day to talk about the details. But I will say, Ray, that the ASTM standard is tied to CERCLA hazardous substances. And so that's why, as you said, PFAS are not part of the scope because there are no PFAS compounds currently listed as hazardous substances. That's probably going to change. It will change. It'll change probably this year, starting with PFOS and PFOA. So at least at a minimum, you will have phase 1 consultants considering PFOS and PFOA, but that leaves the other, 5,998 or whatever number of additional PFAS that need to be considered. So it's just a word to the wise that as the hazardous substance determinations are made, that doesn't necessarily mean that you should ignore that part of it in a phase 1.
Absolutely. And again, I think a prudent buyer would consider those concerns today, knowing that PFAS is going to be an issue for site owners in the future.
Right. Well, Ray, let me ask you this again. You have more trips around the sun, as it were. You've seen trends in environmental law over the years. What does PFAS feel like to you compared to previous hot topics that have come about?
Yeah, I think what we've summarized here really follows a pattern that we've seen before, but there are some distinctions this go around with PFAS. But I think the pattern is, you can look back to see what happened when DDT came to the forefront. Asbestos, lead, PCBs, dioxin, radon, mold, they've all been had their time in the spotlight. And what we typically see is an identification of risks that were previously either not known at all or misunderstood, followed by findings of widespread use or the presence, in the case of, for instance, radon and mold, and hence widespread exposure. Public concern growing, then EPA rulemakings, state rulemakings, litigation that you've mentioned. But I think so it's a pattern. But I think what distinguishes the PFAS situation that we're seeing today is as we've talked about, the sheer number of chemicals that fall under the umbrella term of PFAS. The large variety of industrial sectors that have manufactured, processed, or used these PFAS chemicals. And finally, the extent of PFAS in soils, waters, and as you mentioned, in bloodstreams. So it's I think, a grander scale in each of those categories than what we've seen before.
Right. And PFAS is unique. The category of PFAS is unique for many reasons. Another unique reason, and it's why things are difficult to clean up, is that PFAS are, some chemicals are highly mobile in water, but they're relatively easy to clean up. PFAS is one of those chemicals that it's sort of the holy trifecta. It's a complex mixture. It's very stable. And it's very mobile in water. So you can't treat it the way you would typically treat, any other common chemical that we're used to, PCBs and chlorinated solvents, 1,4-dioxane, petroleum hydrocarbons. It really is this almost perfect storm of complexity. So I think we'll probably leave it at that. Maybe we'll have a second episode, a part 2 of this at some time, Ray, and we can delve into more issues specifically. Or I suspect by the time from the beginning of this recording to the end, there have been some changes in the PFAS world. So there will always be updates to be discussed. But thank you, Ray, for talking today. Appreciate your insight into this very fascinating topic.
Thank you, Joel, and thank you to all our listeners.
So with that, if you have any questions about this episode or any other episode or environmental law topic, you can reach Ray or I at thompsonhine.com through our bios. If you'd like more information about Thompson Hine's environmental law practice group, please visit thompsonhine.com. With approximately 400 lawyers and 8 offices, Thompson Hine is a full-service business law firm recognized for innovation in client services. Our Smart Path approach provides clients with services that are predictable, efficient, and align with their short and long-term strategic goals. And I like to end with our warning that this podcast is for informational purposes only. It provides general information and not legal advice or opinions regarding specific facts, especially in the world of PFAS. You may not edit, modify, or redistribute this podcast without permission. So again, thanks, Ray. Thank you to all of our listeners. Stay safe and be on the lookout for our next episode soon. Bye.